immensely popular. Welcome everybody. If I just got cut off, I'm not sure. Welcome to this webinar series. It's been immensely popular, what we've been trying to implement to try and provide some ongoing professional guidance through the ARBV and through the knowledge that we have from their feedback. So I'll just commence today, just changing slides with a welcome to country. Acknowledgement of country. We respectfully acknowledge the traditional owners of the land, which wherever attendees are situated, in particular the Wurundjeri people and the Bunurong Wurrung people of the Kulin Nation, and paying respects to the elders past, present and emerging. Just like to quickly welcome everybody today. We're actually dual hosting today, and I'm thrilled to also possibly publicly acknowledge that Rebecca Naughtin's joining me today and also helping me as the co-convener for the Registration Board of Victoria. Rebecca's an architect, business owner and educator, and in addition to many of these roles, she's now also a convener. So she serves on various boards, and her insights and experience have played a vital role in shaping policies and strategies within the education sector. Rebecca's involvement with the ARBV's has been many years as an examiner and now co-convener. She plays a vital role in upholding professional standards and ensuring the integrity of the architectural profession in Victoria. Rebecca's dedication to advancing the fields of architecture and her active involvement in governance and professional participation underline her commitment to the growth and development of architectural community. So Rebecca will be helping me with today's presentation, and she'll be looking at the second half of the presentation. For those of you that don't know me, my name's Emma Templeton, and I am also a co-convener for the Registration Board of Victoria. I have my own practice also, and I'm involved in education through the university systems. The purpose of today's webinar is all about the architect agreements that we all, the client architect agreement, and also the partial services component, which seems to be growing in regularity, to be honest, in this environment. So we are hoping today that we'll get through a module that will cover in terms of the practice management and professional conduct, the project initiation and conceptual design, and the design, delivery and construction phases of the word I'm looking for. I'll come back to it. By the end of this 1 hour module, participants will understand the importance of client architect agreements, understand how and when to vary a client architect agreement, and the risks and better practice when architects are engaged for partial services. Partaking in our interactive assessment will allow participants to claim one formal CPD point, which requires you to undertake some questionnaires during this presentation, and a statement of completion will be emailed to participants at the completion of this module. So in this first section of the webinar, we're going to talk about why client architect agreements are important, architects' responsibilities, which to our clients and under the Act and Code of Conduct, the importance of communication, the recourse when it's applied, and just talk about a couple of scenarios that have been things that have come up in terms of the ARBV's involvement with architects and client disputes. So we'll start with what is a client architect agreement and why it is important. So the success of a construction project is likely to depend heavily on a client-architect relationship, and a positive client-architect relationship typically ensures that a client's core concerns are addressed and communicated clearly throughout the process. These concerns are likely to include the regular things like time, budget, and the being built in accordance with the specification. And I guess with budget, it's the project budget, the whole budget, how the architectural and professional fees impact, and as well as the construction costs. In the experience of the registration board, the modest number of complaints regarding architect service, mainly concerning residential projects, could have been avoided through better communication. And if the client had a more detailed understanding of what to expect from an architect providing services. And the client-architect agreement is one of the first steps in creating a positive and clear communication with the clients, resulting in a better client relationship. And the importance of this is reflected in the regulatory requirements of Victoria. As architects, we're all working under a regulatory code within the Act of the Code of Professional Conduct. And in Victoria, this code of professional conduct includes these requirements: a written client-architect agreement. Clients must discharge their obligations diligently and promptly, and architects must keep clients informed and respond with reasonable promptness to client requests for information. These regulatory requirements are designed to ensure that the client-architect relationship is well managed. This is directly taken from the Code of Conduct, and I'll probably go into it more as a summary, but as our duty under the Act and under the Code of Conduct, so Clause 4, an architect must not provide architectural service unless the architect or approved partnership or company has entered into a written agreement with the client for the provision of services. Okay, and then the agreement has to include the following things: the parties to the agreement, the name of and registration number and contact details of the architect responsible for those services, the scope, nature and specific requirements of the services, the time frame for providing the services, how the professional fees and costs will be calculated, where possible, reasonable estimates and disbursements, how professional fees and costs, including disbursements, will be paid, how the architect may inform the client of progress in the provision of those services, and how the architect may authorise the architect, how the client may authorise the architect to proceed with services or any part of services. It's also a requirement that the architect must inform the client of how a change or amendment to services will affect the professional fees or cost of the service, how the architect may obtain the client's authority to change or amend a service, how variations to the agreement may be made, a reservation of the right of an architect to withdraw from the provision of services under the Clause 14, and how the agreement may be terminated and from what reasons. A subclause applies to the agreement for the provision of architectural services entered into by an architect or approved client on or after the 15th of July. But that's it's quite a lot of responsibility that needs to be condensed into a user-friendly document that protects both the consumer, your clients, and you as the architect. So we'll go on to the next page. So a written client architecture agreement is a requirement. The scope, nature and specific requirements of the architectural services should be outlined. And this is where it comes down, and we'll talk much more about partial services, full services, and how all of these different types of services that we provide, which we'll have a look at, might be charged in different ways. Timeframes for providing these services, terrifying, but to provide a design service and how likely each stage is going to take. And I know there's a number of, you'll all be nervous about how you predict such things with clients having such control, but some sort of estimate and disclaimers in the timeframes providing services is a requirement. The manner in which the professional fees and costs of service would be calculated, which, if you're talking about a percentage fee and then some services at an hourly rate, so it's quite a detailed analysis of how you would be charging for that, and the way you would inform a client of progress regarding the provision of services. That almost, and a lot of architects would work in a similar way in terms of the percentage of works complete and how that would be communicated with the client. The requirement of an architect, it's a requirement that the architect must inform the client how a change or amendment to the service will affect professional fees and costs for services. I know that most of you will have had to work with scope creep or escalations of costs during this really challenging few years, and it doesn't seem like it's getting any easier very quickly. So those amendments to services, how that's communicated and how the professional fees for time delays, for instance, are really important to be spelled out in this agreement. How the agreement may be terminated and for what reason, and the correct information, including the registration number, which is something that's sometimes neglected to be included, and the signature is clearly. So the important part of this, that a failure to comply with clause 4 of the Code of Conduct is an automatic breach of the Act. So we have a really challenging job to try and work on quite long relationships that have a fee structure that spans a long period of time, timeframes that are harder to control unless you're pulling them into smaller chunks of the services provided, and an approval process that requires on the client or other authorities to make those timeframes work. So the clarity with which the client architect agreement sets these things out is really kicking off how your relationship and communication works with the client. So really important that the professional fees are isolated separately and the disbursements are covered as well, so that that's not a surprise. The last thing clients like are surprises with professional fees. How the architect may inform the client of that progress, and we'll go to a pro forma in a minute on that. How the authorisation might take place in order to proceed with the next stage of a service. That's a common issue, is to moving on to a stage before a client agrees that it is complete. So how that process may take place, so it's clear from the outset. Amendments to services. So again, it comes back to additions or scope creep or changes to the scope, and how we communicate those back to the client rather than just being absorbed by the original service agreement. And we'll just go down to this, and then I've also just listed here a number of additional services that are sometimes not included, or sometimes are more increasingly isolated from your lump sum or traditional percentage fees, as some of the regulations become more difficult to predict in terms of time and requirement. So the handling of additional services and associated fees, like report and consents for dispensations to building regulations, which has become much more common even in the residential sector, since a lot of the building surveying work's been taken out of the town planning process, and it can be a very time-consuming process. So that might be separated and would need to be clearly explained in a fee proposal and a client architect agreement. Amendments to building permits or staged building permits, if that's requested, and how that would be charged separately. Town planning services, applications and negotiations. So often I know architects generally will charge an hourly rate once a town planning submission has been submitted for all of the additional work that might be required post that submission date. Contractor selection, construction and post-occupancy consultations. So whether those things are included or if they're seen as additional services. Neighbour negotiations and protection works. Again, if they're included or an additional service. Performance-based solutions, value management, and often interior design services such as soft furnishings, etc. Oh, don't go too fast. So this is just an example, because one of the things that's that throw the client is a surprise, and variations are a surprise, and often, unless communicated well, can be assumed to be part of the service that you originally agreed to, or the scope. So the Acumen has a scope of service variation, which is a really helpful document to identify what the variation is, whether that might be an addition to the scope or whether it's a staged permit, however that variation is. It summarises the reasons, provides the costing base for future bases, and advises any programming implications, potential budget implications, and provides a really clear record of communication. This would help inform if this is how it's going to, this is how you intend to communicate a variation to service, then that would need to be clearly identified in the original client architect agreement. I feel like every time we do a webinar, we talk about communication as the most important consideration, and there's good reason for it. But architects' capacity to meet their clients' expectations is often difficult, and the capacity of an architect to meet it depends on some factors that are not always controlled by the architect. It might be the type of client, it might be the type of project, or it could be the contract with which the architectural services are sought. So we can be engaged by owners and end users for small residential buildings that have very little knowledge or sophistication around the construction industry, or we could be engaged by developers or builders who have very different requirements, or in multi-storey or residential, and that will affect how that client architect agreement works and how much control you also have over it. So the degree of knowledge and sophistication, the motivations and perspectives of the clients are likely to differ in each of these contexts. And this is where the challenge of our profession is, that we need to be able to manage each of those specific situations. And managing these differences and expectations is one of the challenges of the profession. However, communication is often the key to establishing and maintaining a good client-architect relationship and avoiding conflict. A survey taken by the AIA in 21, clients rated effective communication as the most important factor in their relationship with their architect. So for me, that means that a lot of the time conflict can be avoided through communication, and from the outset, if you've got a clear document that outlines all of these, the way the process is going to be managed, then you've got a really good backstop to rely on as you go through the process and questions come through. Sorry, I can see people are in the chat. I will have a look at that in a moment, or Beck might have already looked, but I'll get through a bit longer and I'll come back to you. So clients' access to recourse if there's a breach. So if your client architect agreement, or if the provision of services is considered, that the client considers worth reporting, the ARBV is able to receive and consider complaints made by aggrieved clients about architects. So if the ARBV then decides to refer it to a tribunal as a result of the inquiry to the Act, one of these following determinations can happen. So if your client architect agreement doesn't have all those requirements that are in our code of conduct, this is where it could land. So you could get a caution, you could get a reprimand, You could be asked to undertake further education, or to impose a conditional limitation on your registration, to impose a penalty not exceeding 50 points. So that's a financial penalty. That's a state government unit. I think that the maximum's around $10,000. To suspend, I think that should say, the architect's registration for the period stated on the determination, and to cancel the architect's registration, and make any determination as to costs that as it thinks fit. So it's got reasonable power to apply should you find yourself in breach of the Code of Conduct or the Act. So in terms of trying to create a watertight client-architect agreement, and many architects do prefer to create their own client-architect agreements for whatever reasons, because of the specific clauses they want to include, or because they find that they can do it's more personal in their approach. We don't really have time today to cover this in detail, and also I'm probably not qualified, but we would encourage you strongly to seek legal advice when you're creating a bespoke agreement. Alternatively, there are a number of client architect agreement templates available for you. There's the one produced by the AIA, which I think most of you would be aware of. Architeam have recently written their client architect agreement, and the ACA has also got they've got a short form architect agreement that's worth having a look at if you're members of that all have been designed to be compliant with your responsibilities under the Act. Okay, so in terms of the ARBV and what they receive in terms of complaints, or some of these are just drawn together over a number of years. One of the problems is when we hear about an oral agreement. So in the given scenario, there's various instances where the responsibilities and expectations between the client and architect are unclear, leading to confusion and potential problems. We'll break down each scenario and discuss the possible issues. So in scenario one, there was an oral agreement without written terms of engagement undertaken. And in this case, I think it was a extension to a house. There was a lack of clarity regarding the roles and responsibility. That's right. Roles and responsibilities of the client and architect as a result of the no written terms of engagement, and where the client's role and the architect's role divided. And the project came to a halt due to an expired permit, which is a planning permit, and both parties blamed each other for the responsibility to seek an extension. And so this broke down the relationship entirely. And I guess it's interesting to look at those oral agreements, which can often be with people that you know, and you don't take the formalized steps to avoid these things. So it's important to have a written terms of engagement that clearly define the scope of works, responsibilities, and project management aspects of the project. The architect should be mindful that the client may be inexperienced and provide guidance accordingly. And I guess the issue with these oral agreements that might come up from time to time is that they are usually with clients that are very inexperienced, in which case there's a sort of failure of the professional role that the architect takes. Okay. We're up to the question, one of the questions. I think we have 4 questions today. So true or false, the architect must inform the client on how a change, it's gone up in the middle of my screen, how a change or amendment to the services will affect professional fees. We'll give you a few seconds to complete that, because I think it'll come up on your screen. We'll have a quick look at the chat. Move that to one more. We've got another scenario to have a quick look at. Okay. Some of these no formal agreement scenarios happen when there's inappropriate client-architect relationships, for want of a better description, where the architect's engaged potentially by family or friends, a neighbour, something like that, without adequate client-architect agreements, roles and responsibility. So the client is not aware of the responsibilities usually carried out by the architect. Again, we're talking about an unsophisticated client in this case, leading to delays and issues with relevant applications. So expectations are not even set out from the outset. So it's always going to be difficult then to be able to manage that expectation and timeframes and even the costs. So even when assisting friends or family, it's essential to have a formal agreement and clearly define the scope of works and responsibilities. Architects should consider using an client-architect agreement for their own protection as much as to ensure the clarity of their working relationship. So I've got another question for you here, which is an architect pursuant to the clause 4 of the Victorian Architects Code of Conduct must clearly identify how an agreement may be terminated. Okay. It gets more complicated when we take on partial or limited services. Sorry, Beck, I'm not sure if I'm touching it. So I'm going to hand over to Rebecca to talk about partial services. And should we get time at the end, sorry, Beck, I've gone exactly to the half hour, we will come back to your questions.
All right, thank you, Emma. So I have been through some of the questions, and I think I'm going to be able to pick up on answering some of those as we go through the content on partial limited services. So today we're going to be focusing on understanding what is actually considered a partial service, the key considerations, risks and mitigation, and just a few scenarios similar to what Emma went through with her presentation. So as Emma did introduce, there is an increasing prevalence of partial services engagements in architecture. Clients are seeking to engage an architect to provide partial services for a variety of reasons. One of them just being for a feasibility study, say, to assess the viability of a project. It might be to prepare drawings for the sale of a property even. They might be for design only, for documentation only, taking on the work of a former architect or former building designer, for design and documentation only, for partial contract administration, so as you'd be familiar with D&C or novation, and the architect is engages a secondary or sub-consultant to a primary consultant, which we're seeing a lot more in what could be a PPP, and then full stages with reduced services to avoid the fees for a full service as part of a selection process. So this is really an important point, that all of the services that are nominated on a standard client architect agreement, and we'll say the institutes, that they are recognised as full services. As soon as you start removing those services for any reason, whether it to reduce your fee, which is the common need to reduce, to be able to provide a service, you are in fact providing limited or partial services. So there is a contract that you might, or a short form it used to be called, that Emma didn't list in hers. It's the Client Architect Agreement by the Institute of Architects for Limited Services. And these are some words from Acumen that describe this particular contract. They claim, being the institute, that most institute standard form contracts are unsuitable unless administered by an architect. And down here, that it is not suitable or direct alternative to the full contract. It is for limited engagements with low value and low complexity. And there has been a perception that a prospective client will be more receptive of a shorter form for a smaller project. However, the longer form provides just a better platform for customization and for protecting the architect. So some key considerations here in partial service engagements. So fee negotiation and structuring for partial services. It might include all of the stages of a traditional agreement with reduced deliverables. We're going to be banging on about clear and concise communication a lot today, because we know what problems, what is reported to the registration board, and it really is about clarity in communication. Having a very clear client architect agreement, and consider using the full agreement, and striking through deliverables for the services that you're not offering, and then that still protects you in the small fine print. Limitation of liability insurance considerations. It is important that in your fee proposal, or when you are meeting with your prospective client, that you discuss the limitations that may be applied to your services, legal limitations, very early on at the outset, because later on we don't really, it's not appreciated when they're a surprise. And I'll be going through a little bit of wording about how you might be able to communicate that better with the client. With the client architect agreement, always refer back to the client architect agreement and make sure that you're not in breach of your obligations. Another item or consideration here is withdrawal of license, and as a clause in case there is a breach. What does constitute a breach? Well, it's a non-payment by the client, unauthorised design changes and alternative site usage. So we all are familiar with the copyright, that the architect retains copyright unless it's negotiated otherwise. And then the client has the license to build that design once on any particular site. So that there is real commercial value in a license, to be discussed a little bit further. With addressing copyright and moral rights, when you are in partial services, there is potential that a design is not executed as the design was intended, and these are considerations when you are discussing handing over a design for documentation by another party, or for construction stage services by another party. You may not have any involvement in construction, and this is problematic because the construction stage might actually be administered by a person who's professionally not qualified for administration, and they just don't understand the design intent. And also, we're just going to have a touch on partial service during the construction stage and certification, and limiting some liability in certification. So chronologically, let's just start with feasibility. You might be engaged just for feasibility or pre-design, just design or documentation. Yes, you still need to have a client architect agreement. The terms of that agreement in relation to the license granted to the client must be very clear. If they're unclear, that is a breach of your obligations. The limitation of liability regarding compliance with building or planning codes, being clear on the purpose of the documents that the architect has provided. So if you're only providing documentation to a particular stage, you need to be very clear that perhaps they're not going to be fit for construction. Most likely they won't if it's a feasibility study. Amendments to the design with the architect's consent is an issue. There may be no opportunity to correct any errors or omissions during construction. You, as the architect, may have no recourse on substitutions that the builder might make. You could request to have inspections during construction. However, if accepted without limitations and being very clear with the client, you could expose yourself to full liability, just as if you had been engaged for full contract administration. Coming back to that contract administrator not being experienced or qualified in terms of potentially a project manager, and always seek advice from your professional indemnity insurer. They love a phone call, so and they don't want you to be going through any pain or suffering too. So just give them a call to qualify. So this really stands out to me as being an important point, is that the architect's documentation of a building normally describes the end result, not the means of achieving that result. The responsibility for construction methods rests with the contractor. So if the architect is not involved in construction, then there's a missing link somewhere. If the services exclude contract administration completely, you should write to the client and recommend that inspection during construction stage is carried out by a competent, experienced, independent inspector. And quite often, I know through my experience, there's a conversation about omitting construction stage or contract admin from our services because there's a fee involved in that, and they'd rather put my fee into buying, upgrading the stone bench top on their island bench. The problem here is that then the client, and especially if it starts becoming a more complex project, isn't going to be experienced enough and probably will find themselves with a bucket full of variations that they aren't able to assess. Advise the client that issues will need to be addressed during construction to assist the contractor in completing works. So I do hear a lot about design and construct contracts where there is provision for an architect to provide advice during construction, and it's something to be very, very wary of. If it's for design only, your fee proposal and your agreement should provide a clear statement, something along the lines of, the architectural services are for design only. Be specific, preliminary, schematic, indicative. The design drawings are not suitable for building approval or for construction purposes. They can go on everything up to the point that you're actually, you've completed full documentation, you have a building, you're applying for your building permit. If the architect is engaged for partial construction stage services, this is something that we've taken as a snippet from Acumen. During monthly site attendances, the architect's duty will be to confer with the builder and client to answer specific questions regarding design problems or concerning the documents put to them by the builder, and the architect will inspect such items of work specifically referred to them by the builder and the client only. Because the builder is responsible for the superintendence of the work, the architect has no obligation or duty to ensure that the construction work is in accordance with the contract documents, and there is no general duty cast on the architect to supervise or inspect or generally to observe the progress of the works. So jumping to the other end, construction stage services only. If you are considering taking on a project from another architect or other building design, it's important that you provide within your fee agreement and calculations adequate time to inspect the documents prior to calling in tenders or contract negotiation. The documents you need to examine the product to make sure that it confirm that it meets the intended purpose. Coordination, ensure each party knows Who is doing what? And that's really important in when you are acting as the subcontractor or sub-consultant. Consultation, which I've just confirmed there, consultation between primary and secondary consultants, make this clear. Who is coordinating knowledge from authorities? How is the information shared? And I know now there are platforms such as AConnex, which make it easier to share information, but it's really important to have it clear on who will be, how it's going to be shared. How will the architect be acknowledged? Perhaps some signage. How will they be attributed in a magazine? Architects should not give away their intellectual property without appropriate consideration. And in quite often in cases where the architect is only at the front end in design or only in the back end, let's say there are two consultants, in most cases, both will own the copyright jointly as a default. Certification and subcontractor secondary consultant engagements. So architects may be asked to state that the project is constructed in accordance with the contract documents, even though the architect has not undertaken the contract administration and may visit the site infrequently. And we hear this a lot in registration interviews about in D&C and novation. It almost sounds as though the candidates are actually undertaking the tasks that are normal to contract administration services of an architect, and they're asked to confirm that the building work complies with all codes and standards. We can strongly recommend that architects avoid any situation like that, where they're asked to certify where they haven't been involved in full services. When providing a certificate, which is in essence a guarantee, it can expose the architect to litigation. So certification and subcontractor or secondary consultant engagement. So only in instances where it is written into your agreement that you will be certifying, only provide a certificate if you have that obligation. Always ask yourself, can I honestly make this statement that I'm being asked to make? Do I have all the information and all the expertise I need to have to make the statement? And if the answer is no, you just don't make the statement. Only provide certificates addressed to and in favour of your client, and don't provide copies to third parties. Include a disclaimer in your certificate stating that you accept no liability to any third party who may try to rely on the certificate, and get legal advice on the appropriate wording. Only allow senior staff to provide and sign off on certificates. And what's important is also agreeing to the wording of a certificate before you start work. And this also comes back to what Emma had shown, which was that instruction for a variation to the architectural services. There is a recommendation to provide a copy of that when you do provide your client architect agreement to your client, so they can clearly see how to vary the scope. So just a little bit of a run through on fee calculations and agreements, just some guidance when you are working with partial services, because those responsibilities and who they lie with will have quite a profound effect on your fees. So who's in control of and attendance at meetings? What is the procedure and responsibility for variations? Authority for giving instructions to the contractor. Arrangements for issuing certificates. What are the fees, terms and methods of payments, and are they clear? And this is specifically acting as sub or secondary consultant. What are the travel expenses and other reimbursements? Evidence of professional indemnity insurance is held by all consultants. If in doubt of the adequacy of insurance held by others, ask your broker for some advice. Be clear on the copyright ownership and how the moral rights of the authors of the designs are to be attributed and managed. And if the primary consultant, as agent for the client, appoints the architect as a secondary consultant to the client, the primary consultant should be asked to obtain a letter from the client agreeing to the appointment and to the relevant conditions outlined above, similar to how you would if you were seeking services from another sub-consultant or secondary consultant, such as an engineer. One of the problems we just mentioned briefly before about partial services is quite often they are requested to lower the fees. There has been a conversation about fee cutting or slashing or whatever one may want to refer to it, but it is a reality that that lower fees can sometimes win projects, and when the cost of money is so expensive to borrow right now, fees and pricing for architectural services are paramount. There is nothing to be mistaken about. Lower fees result in a lower level of service, and that doesn't mean a lower quality of service. It just means potentially a lower amount of deliverables. It often, though, results in a temptation to reduce time required to design and document a project, resulting in a higher chance of litigation. So address the challenges of low fees in architectural services, clearly defining that scope in the client-architect agreement, specify that time period of the service provision of any additional fees for extended durations, outline the engagement and payment terms of secondary consultants, state the number of design options to be prepared during a design stage. We also list the amount of meetings per stage as well, so there's a limitation on those. And any design meetings required after that would be charged at a particular rate. Set clear terms for the client-architect agreement and progress fee payments, and consider a lump sum fee in certain market conditions for both parties' benefit. Using appropriate language. So in my professional opinion, or to the best of my knowledge, information and belief at the commencement of your certificates could be used. This is in partial services when engaged for construction stage services. Preface any otherwise absolute statement by reference to limitations on your assessment, such as based on my periodic observations at the site and in accordance with my last visit on the site. State at most that the building work is substantially or generally compliant with the design intent. It's very synonymous with approval of shop drawings. There will be always construction details that are beyond your ability to observe, not being present on the site often, especially. If you must certify that any work complies with a specific document, make sure it is a document that is known to you, such as your own contract documents, rather than a vague or unknown standard, such as the client's requirements or the requirements of the head contract. I'm going to skip this one here because we went through it a little bit earlier, but just a couple of scenarios. I'm just mindful of time. No contract administration engagement. So there was in this case, there was inadequate sharing of documentation. The architect wasn't engaged for construction or contract admin. The client was discussing and providing information directly with the contractor and not providing any of this information to the client, to the architect. So there was an error in the architect's drawings because they weren't aware of this particular piece of information. And then there was a dispute due to the error between the client and the architect. So having that discussion with your prospective client and your client throughout the process, have effective communication and collaboration. The Architects should also emphasise the importance of sharing all relevant documentation to avoid misunderstandings and ensure the hierarchy of documents is clearly explained to the client and the builder. So the architectural specification takes precedence in this scenario. The second scenario here is design and contract documentation only. There's a separate engagement for design and construction documentation. The issue here was that the client expects the architect to undertake a contract and administration activities, even though it was not part of the architect's engagement. The impact, confusion, the potential conflicts arise as the client who is not qualified or skilled in contract administration expects the architect to then perform those duties, even though they're not formally engaged to do so. And the lesson here is, again, clear communication, essential to manage expectations. If the architect is not responsible for contract administration, it should be explicitly stated in the engagement agreement, and the architect should be made aware of the limitations of the architect's role. So we're going to have another poll here. True or false? Design and construct contracts limit the architect's liability as the architect is not responsible for certification. I'm going to assume this poll is closing shortly. Here we go. All right. And do I need to talk to this one, Emma? The answer? So the sneaky wording of this particular is reminiscent of doing registration, and the word is the architect is not responsible for certification. Well, the architect might be responsible for certification, and it all depends on the agreement in place. And we'll start off with this next poll. If the architect is only engaged for advice during the construction stage, they cannot report discrepancies in the quality of a build to the client. Okay, so the answer there is false. So they can, and it's I think the terminology, perhaps a whistleblower clause, could be incorporated into the agreement, but there's many ways that an architect now can modify or participate in construction stage services, not as contract administrator, and be able to report discrepancies in the quality of the build to the client. Oh, sorry. So in summary, architects should be mindful of their responsibilities regarding their agreement, provide guidance to inexperienced clients and establish clear boundaries to avoid confusion and potential problems throughout the project. Communicate clearly and don't avoid difficult discussions. Poor communication can compromise the client-architect relationships. Prior to architectural services commencing, adopt a comprehensive client-architect agreement that contains the detailed scope of services, fees, and how the parties will manage variations, and not to forget all of the items from the Victorian Code of Conduct that Emma listed earlier. Collaborate with your professional indemnity insurers and legal experts on seeking advice. Importance of preserving copyright and moral rights with your designs. Vary the client architect agreement with appropriate information and at appropriate times. As a bit of rule of thumb, you might set if the project budget increases by 5%, that will trigger a variation, but that there's no real guidelines, but you need to use your own intuition on what is feeling like extensive scope creep and what might trigger a variation. Ensure you obtain the client's written approval of the drawings before proceeding to the next stage, and provide clients with written correspondence that summarizes all verbal conversations. And from a regulatory perspective, from the registration board, architects should also be cognizant of reducing the risk of being in breach of their professional conduct obligations in regards to the Victorian Code of Conduct. So we have quite a few questions here, but I'm going to ask Emma to join me and see if we can.
I'll unmute. Thank you, Rebecca. Yeah, we've had a couple, but I liked the first one, which talked about reasonable promptness, which I think is it's a relevant question to us, what's reasonable, and it would be assessed in that sort of tribunal kind of assessment of was unreasonable. I mean, I have my own rule of thumb that one should respond to a client email within 72 hours. That's my own but I think that some of that reasonableness comes down to how the timing frames and the number of meetings and the stage of the project. So it's really hard to respond to that over the whole duration and journey of an architectural project. Whereas, you know, once you're into a contract situation, you've got some terms to work with. But that's very different when applied to a design stage of a project. So I'm not sure if that will have helped the anonymous person that asked that question. Do you want to go to one, Beck?
Yeah, Simon has a good question here. And, you know, I actually think I need to
do the timeframes.
Yeah, but I need to do a little bit of digging on this one, and in being aware of that that requirement, we personally have built our timeframes into our fee agreements, our fee proposals, and we refer to our fee proposals in our client architect agreements that set that up. But I think we might do a little bit more digging on that one, because I know that the Institute are currently reviewing some aspects of their client architect agreement. So watch that space as well.
Hopefully everyone could see that question, but Simon asked a question about whether the AIA fee agreement was legal because it doesn't have timeframes in it. And I do the same thing as Rebecca, not necessarily specifically for that purpose, but our fee proposal, which we then reference in our client architect agreement, has the timeframes set out in it, but that doesn't answer your question. So we'll have to come back to you on that. We are out of time, so I'm not exactly sure how strict the ARBV is going to be with us. I'll just flick through quickly and see. There was a lot of the questions, or the first questions, were around do you need a client architect agreement to provide initial services, early services? My understanding, even with a feasibility study, if you're engaged to be paid for your professional service, then you'll need an agreement. maybe that agreement might be a letter that covers these things in a much more simplified form, because your scope of works is also so much more easily defined at that early stage. But there would still need to be an agreement that meets those criteria. But I think it's a simpler task. But as soon as my understanding is, as soon as you are being paid for your professional service, then you would need a client architect agreement.
In regards to recourse, if a client breaches the client architect agreement, that is VCAT as far as I'm aware. But hopefully there are other strategies that can be employed prior.
I was thinking about that one too, and really, because we're coming from a consumer protection point of view today with these hats on today, that might be actually something you'd be referring more to the institute or another associated, that's going to be more about the architect's rights than the client's. But yes, VCAT ultimately.
There is a question here about offering, if a client requests a copy of CAD files, and use of IP, and this is also one that I would highly recommend that legal advice be sought. But this is discussed certainly within the ARCA team group, and there are several now CAD disclaimer and liability waiver forms that are out there in the market that might be worth following up on.
Probably we've exceeded our 1 hour allotment, so thank you everybody for attending. I think this will all be available on the website, and we will also try and answer these questions in some way. We'll talk to the ARBV on how that would work. But we'll hopefully see you at the next webinar in the first half of the new financial year. Thanks for everyone for coming.
Thanks, everyone.